Probate of a will is available when a decedent dies testate, meaning with a valid last will and testament. Usually, it is necessary to probate a will if creditors need to be paid, if property needs to be collected, or if assets need to be distributed to beneficiaries. The most common form of probate occurs when a will nominates an executor to administer the estate in accordance with the provisions of the will. Welcome to or welcome back to my channel. I'm Kizzy, certified probate real estate advisor in the Dallas-Fort Worth Metroplex. My team and I specialize in helping executors, administrators, and trustees with homes and probate or a trust administration. If you're here, then you're probably curious about probate or have been appointed as a personal representative or PR of an estate in probate or a trust. This video will help you to understand the probate process. The probate is the orderly process of winding up the business affairs of a person who has passed away. The court determines whether a testamentary document is the true, last, and valid will of a decedent through the completion of certain requirements. Probate assets are assets controlled by the decedent's will and or its estate, including assets titled in the decedent's name without a designated beneficiary. Successful completion of probate distributes property assets among beneficiaries, creditors, and others with a valid interest in a decedent's estate. The judicial probate process begins with the filing of an application to probate will and for issuance of letters testamentary. This application is filed with the county clerk. Typically, an executor named in a will applies to the court, requesting the admission of the will to probate. However, Texas Probate Code allows any interested person also to apply. The Texas Probate Code, or TPC, definition of interested persons includes heirs, spouses, devisees, creditors, and others having a claim against the estate being administered. Following filing of the application, the clerk will post citation to all parties having an interest in the estate to appear in the case if the party wishes to do so. The clerk also sets a return date for the application. The return date is the date that the application is returned to the clerk's office following the posting period. No hearing to probate the will can be held until after the return date. At the hearing to actually probate the will, the executor presents proof to the court regarding the decedent's death and the will. Following a determination that the will should be admitted to probate, the judge issues an order probating the will and appointing the executor. The executor then takes an oath to well and truly perform his or her duties as executor. And finally, the court issues letters testamentary to the executor, certifying the executor's authority to settle the assets of the estate. Letters testamentary are official documents issued by the court authorizing the executor to act for the estate. They are proof to others that the executor has been qualified by the court. If there are multiple applicants who are all equally entitled to be appointed, then the judge will appoint co-executors or co-administrators or will determine who is to receive the letters testamentary or letters of administration. If you are planning to sell a home in probate, I do have a free Texas probate guide that I would love to send you. You may request it via email at kizzy.grant@exprealty.com. Thank you for watching as always. If you found this video valuable and helpful, please like and subscribe to my channel, and also click the notification bell so that you will be notified when new videos are released. And I'll see you in the next video.